Yes, Miss Gallagher. Thank you. Forgive me an elegant swig just before starting. And I will do this in half an hour. I'll tell you what my plan is. So first of all, I was just going to pick up at the outset, because I think it'll save time, just two very short factual points. Then I'm going to turn to each of the three grounds. I'll do them in order set out in the skeleton I had for speed, started with ground 3. But I'll do grounds 1, 2 and 3, the substantive grounds. I'll pick up the questions which were asked on the substantive grounds. I'm so sorry. I see there's a...
I'm sorry, I've discovered I didn't prepare.
No problem. Well, we had no wig, you had no pen. We're not doing very well with moving from a remote hearing to an in-person. My lord, do you have it? So I'll do grounds 1, 2 and 3, and I'll pick up the questions which arose on those substantive grounds. And then I'm going to turn finally to relief and ground 4 and answer the questions there. And I think I can do that comfortably within the half hour. So the first two short points are these. The question I was asked just before the break about the number of local authorities. I was in fact thinking of a number over 300, but that's of course not the local authorities who have children's services obligations.
Yeah.
And that number is 152 on the Ofsted statistics. So it's 152 local authorities responsible for children's services. But just it's worth saying this at the outset. We, of course, don't have evidence about the picture in a large part of the country, save that we have the criticisms in the family division cases and some of the other materials in general. I should say that while there are 14 of those 152, so 10% of local authorities, essentially, 1 in 10, who have commissioned and fund secure children's homes, it would be preferable to think of pockets of good practice rather than only those 14 areas. So Barton Moss in Manchester is run by Salford City Council, but of course it also facilitates children from the local area. The key issue in this case is about London, which has a high need and zero accommodation, and the particular example within London is the London Borough of Waltham Forest.
Yeah.
So it's a pocket of very poor practice. And there may be other pockets of poor practice across the country. We don't have the detail of that. But we don't want to give you the impression only 14 of 152 are compliant. That'd be quite wrong.
I was just wanting to put it in context.
Of course, and I was concerned that perhaps in some of the submissions I might have given that impression, and that's not correct. And the second quick practical point is the Concordat. Just for speed, I didn't turn it up, but I think it is worth just looking at one page in the Concordat. So that's in the supplementary bundle. It's page 271, it's about halfway through. It's in a tab which is marked as tab B3, which is the witness statement of Amanda Gordon, but it contains multiple documents. So the Concordat starts at page 243 within that tab. So it's a tab that has the London Protocol and then the Concordat. I just wanted to give you the reference at page 271, which my learned junior and instructing solicitor quite rightly pointed out I should draw to your attention. And that is the guidance in the Concordat in relation to the PACE section 38.7 certificate when you're within the exemptions in 38.6 A and B that we looked at earlier. So first of all, if you look down at the bottom of the page under the heading Secure Accommodation, do you have that?
Yes.
You'll see at the very bottom of the page it says, if secure accommodation was requested and was not available, then the police may lawfully continue to detain the child. This is the case even if the local authority has failed to meet its statutory obligations. And in the background documents you can see there was a concern that the police may be acting in breach of the interests of the child. And it's clear the police are covered in those circumstances even if the local authority has failed to comply with its section 21 duty, Gateshead duty. And then in relation to impracticable transfer, in light of a question in particular from my Lord Justice Elias earlier, I thought it would be helpful to draw this to your attention. You'll see that the Concordat says the term impracticable is often misunderstood. It does not relate to the availability of local authority accommodation or transport. It doesn't mean difficult or inconvenient.
I'm so sorry, I miss where this is.
It's page 271 in the supplementary bundle,
Yes,
my lord.
I'm on that page. Yep.
So if you just look in the first column on the left,
Yep.
there's a heading Impracticable Transfer.
Yes, thank you.
It's that passage.
Thank you very much.
Apologies. More haste, less speed. I think. On my part, apologies. So it says, rather impracticable in bold should be taken to mean that exceptional circumstances render movement of the child impossible, or that the child is due at court in such a short space of time that transfer would deprive them of rest or cause them to miss a court appearance. The reason I just note that is nothing turns on that in this case, because that's not how the argument is put against us. But my instructing solicitors rightly were concerned in light of some of the answers I gave off the hoof this morning, that if the court were to express a view indicating that impracticable has a much broader sense, that is something you would need further submissions on, particularly given that this is a Concordat produced after a detailed, lengthy process, multiple agencies feeding into it. You can see when you go back to page 243 the genesis of the Concordat and the process. And that document, that guidance document, has taken that view of impracticable, which is rather narrower. So we just wanted to alert you to that.
But Ms Gallagher, that I think means that when I asked you this morning whether or not impractical would cover the police taking the view that there was such a short space of time that it wasn't right for the child to move it backwards and forwards, and you said no. So I think in the light of that, you probably said that we'd like to revise that answer to yes.
So I think it was, my view is there are of course circumstances in which it may be impracticable and it may fall within that test when it's a very short space of time. The answer that I was giving was that, as I understood the question, it appeared to be capturing a much broader range of circumstances which would be classified as impracticable. May have just been a misunderstanding on my part.
Specifically about the short time.
Well, my lady, that's...
which appears to be answered by that.
Yes, and it's part of the reason why we wanted to draw it to your attention. So turning then to the judgment, may I just note that at paragraph 5.1 of our judgment, of our submissions, our skeleton, we've summarised the central reasons for the judgment, and they're then mirrored in grounds 1, 2 and 3, and indeed ground 4 on relief. So I'm going to take them in order. So on ground 1, you find that at paragraph 7.1 to 7.4 of our skeleton, and this relates to paragraph 72 in the judgment of Mrs. Justice Andrews, and also paragraph 80 of the judgment of Lord Justice Davis. And I should say, we have checked over the short adjournment in relation to the question asked by my Lord Justice Singh in relation to the factual mistake point. So first of all, in our short grounds of appeal, our view is it is covered by ground 1 and ground 3. And we've also confirmed that the passage contained in the updated skeleton, which refers to the error by the court under ground 3, was verbatim in the previous skeleton filed, which is cross-referred to in the application form seeking permission to appeal. there's a reference to 6.1 to 6.6. So there was a cross-reference. It's always been run in that way.
Yeah, just to be clear, that's paragraph 7.11.
Yes, it is. And you'll see with our application for permission to appeal, there's a cross-reference to the statement of Jennifer Twite and to the skeleton argument at section 6. And we've checked that passage was verbatim contained in the previous version of the skeleton argument too, which you don't have before you. So in respect of ground 1, our submission is that the court erred in concluding that the claim is really a complaint about the nationwide lack of secure accommodation due to the absence of funding by central government. This, of course, also feeds into ground 3. And in our submission, it's correct that the nationwide lack of secure accommodation, or at least the lack of secure accommodation across London and in the region of London, is of central concern to the claim, and one of the reasons why this is an important case. But to characterise the lack of secure accommodation as being due to the absence of funding by central government is in error, given how the statutory scheme is formulated. The description in paragraph 29 in our submission, you could, of course, include the words only a few local authorities. But actually, when you read paragraph 29, along with the analysis that you then find in paragraph 72 to 75 of Mrs. Justice Andrews' judgment, it's clear from the reasoning that the view that was taken was this falls at the door of central government. Central government management, local authorities simply feed into the system. And that's a misconception, incorrect.
Can I just ask you this, Ms. Gallagher?
Of course.
The terms of section 82, subsection 2, appear on their face to give the Secretary of State a power to make the grant of their own motion, as it were, not waiting for an application. Is there somewhere a provision that requires an application to be made before they can exercise that power?
So, in respect of that, I believe the procurement system which is in place and the regulations do require an application, and I believe the document attached to the Secretary of State for Education's most recent letter of the 28th addresses that. I will look in more detail to see if I've missed anything.
Don't worry, you've got limited time and you've got a lot to cover, I understand. Of course.
And of course, in a given case, my Lord, I can of course see a circumstance in which there may be a different argument advanced before the courts in relation to section 82, but that's not this case. The absence of secure accommodation simply cannot be attributed to an absence of funding of central government. Secretary of State for Education was quite right to be concerned in the letter of the 28th about there being slurs cast upon the Secretary of State for Education without a proper evidential basis, and we agree with that. It's also notable that financial constraints have not prevented some local authorities from operating secure children's homes in those pockets of better practice, if I can put it that way, in some parts of the country. And in circumstances in which some authorities have chosen to commission secure provision, we say it's not rational as to why the absence of provision across the whole of London can simply be dismissed as a problem of central government's making. Now, Lord Justice Davis said the underpinning complaint in truth is the national picture. That's paragraph 80. And of course it's right that Just for Kids Law and indeed AOR himself are concerned not only about Waltham Forest, but about that picture being replicated in other local authorities. But that does not mean the obligation is on central government. It means that the failures which we say exist on the part of Waltham Forest are replicated in other parts of the country. And I can put it this way, it's not I wouldn't say it's a two wrongs don't make a right scenario, but it's a over 100 wrongs don't make one of those wrongs right. And that's reflected in the concern raised by the Secretaries of State in their joint letter of 2015, 6 years ago, about there being widespread failures. And it's also replicated in those judgments from the Family Division and in the Court of Appeal, and now going to the Supreme Court regarding Section 25 problems and the dire problems across this area. In this particular case, given the statutory structure, we're looking at the particular failures on the part of Waltham Forest. And we're also looking, leading to ground 2, at the failures on a London-wide basis, because the court failed in this case to consider the London-wide failure to provide secure accommodation. Now, the court did have statistics helpfully provided by the Metropolitan Police from PS Bullivant. That's the 342 requests in 2018 across London. Picture for 2017, similar. And the latest material in the new document from Waltham Forest again suggests 0 of over 40 requests in an 8-week period. In our submission first, the picture across London is of significance. The joint letter from the Secretaries of State 6 years ago urged authorities to work with their neighbouring authorities to address this problem of meeting Section 38(6) requests. Second, Section 53(1) of the 1989 Act, which we looked at earlier, specifically provides that this is not just an issue for individual local authorities within the borders of their own area. It expressly provides that every local authority shall make such arrangements as they consider appropriate to secure that homes are available and may do so jointly with one or more authorities. And in our submission, an authority acting reasonably, bearing in mind the statutory purpose and bearing in mind the dire picture shown in the letter from 2015, in PS Bullivant's statistics, and indeed in the most recent material, would take into consideration the large number of unmet requests across London and its power to make joint arrangements with its neighbouring authorities. The court did not make reference to that important context. To the contrary, at paragraph 73, Mrs. Justice Andrews described that requests for secure accommodation are a comparative rarity. She says that at 73. 342 requests in a year is not a rarity in our submission, nor indeed is over 40 requests in an 8-week period in the latest material that we've got. It would be unreasonable for the respondent to ignore that context across London. Now, this also ties into the fact that Mrs. Justice Andrews then says at paragraph 74 that she could not see any valid distinction between the system which was found to be lawful in Gateshead and the system adopted in the present case. And we do not accept that. And first, we indicated earlier when we were looking at Gateshead that the system is set out, and in due course when you look at it, paragraph 8 of the judgment is particularly helpful, which sets out what the system in Gateshead was. That shows the number of requests for secure accommodation there was 5 requests in 12 months. That's page 654E. I don't ask you to turn it up. There was secure accommodation in Kyloe House, Northumberland, which had provided a Section 38 bed until a number of years previously, and it was hoped that Aycliffe Young People's Unit in County Durham was to seek a licence to provide a Section 38 bed. So there had in that case recently been a Section 38 bed in close proximity in Northumberland. There was good reason to hope there would shortly be another one in close proximity in County Durham, and reference was also made to other units in Yorkshire. Now, there was reference in that case to the closest Section 38 bed for a girl at that time being in Hull, which was some distance away. But that needs to be seen in the context above.
2 hours drive.
Apologies.
2 hours drive.
Yes. And then, of course, the call itself in that case, as we saw earlier, was in the course of a conversation which only started at 20 minutes past midnight. So the scenario here, we say, is very different. It cannot be said until recently that there's been a bed in close proximity. Cannot be said that there's an expectation of a bed being available in the near future. There is nothing remotely close. There doesn't appear to have been for a long time. You've nothing like the kind of evidence you had from Gateshead about the changing position, painting a moving train, what they were doing to address the new gap in provision which had arisen. And here also, the London-wide context is critical. Notice needs to be taken not of 5 unmet requests in a 12-month period, as in Gateshead, which includes girls and boys, but 342 requests made across London in a 12-month period, and the argument we set out in ground 2 of our skeleton. And in addition, apologies.
You made a reference a moment ago, I think, and it's my fault. I can't take up.
No, it's my fault going so quickly.
You said something about 14 requests in 8 weeks. Was that in the area of London, Borough of Waltham Forest?
No, I'll get that reference for you. That's in the statement which we got, the disputed statement, but the statement which we got from Mr. Phelps.
Right.
And
sorry, you may have covered this already, but forgive me.
It's across London.
Across London.
And we did go to it a little earlier. Let me just check. I believe it's paragraph 6. I'll just confirm. for you, but it is across London, my lord. Yes, it's 46 requests in March and April 2021, paragraph 6.
I'm slightly troubled by ground 2, because as you have emphasised yourself, the statutory duty falls upon an individual local authority. It does not fall on Secretary of State, and it does not fall on other local authorities. It's this local authority. So it's my fault. I'm having difficulty understanding your ground 2. Why is the picture in other London boroughs relevant to whether this local authority is in breach of its duty?
Of course. Because under Section 53, part of the statutory picture, there's a recognition that where you're dealing with these kinds of issues, you can collaborate with other local authorities. Now here you have a situation where London Borough of Waltham Forest is sufficiently geographically proximate to its neighbours that it's readily able to collaborate. And indeed, there is some evidence of potential collaboration, albeit that it's quite vague, in relation to making joint arrangements with its neighbouring authorities. So quite different to the situation in Gateshead. And in our submission, when you are considering the question of whether this particular local authority within London has complied with its duty, that London picture is relevant, and its ability to work with neighbouring authorities under Section 53, the long-standing picture of a problem across London where you're dealing with local authorities in very close proximity, is relevant to the question of whether or not the local authority has a reasonable system in place. And in our submission, the divisional court failing to address that picture was an error. That's what our ground 2 is. Now, I of course recognise that you don't have a picture in relation to all of the London authorities. It could be that some of the other London authorities, in fact, have taken far greater steps than Waltham Forest have. So what you need to do is look at Waltham Forest's compliance with its statutory obligations, but in doing so, its ability under Section 53 to collaborate with other local authorities and make joint requests is going to be relevant when you look at whether or not it has a reasonable system in place, because it's failed to do that.
So you're saying there's really two aspects to that. One, they have this facility to collaborate, and there's no evidence that when they've seen that neither they nor anyone else in their geographic area has the facilities available, that they should have been proactive in trying to reach an accommodation which would resolve the problem.
Yes.
Or alternatively, if they had done that and all the other local authorities were saying not us, we're broke, then they should have shown that they were taking some other steps, for example, applying for a grant in order to provide local services themselves.
Yes, yes. And indeed, in the defendant's own evidence, we haven't gone through Ms. Gordon's statement in detail for reasons of time, but in her statement, which is at tab B1, it's pages 209 to 211, I don't ask you to turn it up, paragraphs 10 to 13, you'll see she, of course, refers to collaborating with other local authorities in responding. So it seems particularly unreasonable for the claimant to be in a position where the claimant, now the appellant, has collaboration by Waltham Forest with three other local authorities used against it. But then when it comes to us making this argument about a failure to collaborate in an effective way, amounting to a reasonable system meeting its Gateshead duty, we're told you can't do that. You look at Waltham Forest alone. And that just doesn't work. And that passage in Amanda Gordon's statement, 10 to 13 in her statement, and then her attachment AG3 at page 273, you'll see that she's essentially describing them having a Section 25 referral system. It might take some time to get a response and so on. We don't know if all other local authorities that they're collaborating with take the same approach as Ms. Gordon. What you can say on the evidence before you, and what the divisional court should have said on the evidence before them, is that there was insufficient evidence of Waltham Forest meeting the Gateshead duty. And in doing so, they should have considered the London-wide failure for the reasons we give in ground 2. May I turn to ground 3?
I wonder if there's one other point actually arising out of the London statistics. If the statistics are very small, one might say, well, we don't know whether they just happen not to be available to place in a secure accommodation. But when they're this extensive, it suggests there simply isn't the accommodation available.
Yes.
It's not just a problem with the particular request on a particular occasion. It's a systemic problem, that there simply isn't accommodation. And one can perhaps infer that by looking at a wider picture.
We entirely agree, my lord. That's precisely our point, although put far less elegantly than in your question. We entirely agree. I mean, that figure of 46 in March, April of this year is every 1.5 days. There's a child in London in the position AOR was in a number of years ago who needs a Section 38(6) secure bed and does not get it. The answer is always no. 46 out of 46, the answer was no. 2018, 341 out of 342 was a no. So we entirely agree. The pattern is important. And it's also why actually the fact that this is coming before you as a test case with AOR being indicative, the precise toings and froings of what happened on that evening on the 27th and 28th of December 2018 are neither here nor there to the question you're considering. They're about the reasonable system. Because in any system, no matter how perfect, you will get instances where secure accommodation cannot be provided. That will happen. The point is here that secure accommodation was not provided in circumstances where, regardless of circumstances, regardless of the time of the call, the answer for AOR was always going to be no, in the same way that the answer for those 46 children in the last 8 weeks was always going to be no. Could I just come to ground 3? Now, ground 3 is relevant in particular to paragraph 75 of Mrs. Justice Andrews' judgment, and also paragraphs 82 and 83 of Lord Justice Davis's judgment. And that is the round-up ground, essentially. The court erred in all the circumstances in concluding that the respondent system is not irrational. Now, in respect of that point, we've said in our skeleton, we've made clear that the respondent places far too much reliance on there being a national and centralised system of secure accommodation, and that they've fallen into error in doing so in their skeleton, replicated by the divisional court who agreed with their position. And it's a misstatement of the role of the SAN and the role of the Secure Welfare Coordination Unit for the Department for Education. The current statutory arrangement is that the nationwide requires local authorities to comply with their statutory obligations. That's the arrangement. The Secretary of State for Education has material before you not challenged about the role of the Secretary of State for Education and adopting a relatively hands-off approach and allowing local authorities to have leeway in how they comply with their gateshead duty and the precise arrangements of their system. If we look at the 3 passages I've mentioned, 75, 82 and 83, at 75, page 65 of the bundle, Mrs. Justice Andrews says, it was rational for Waltham Forest to enter into centralised arrangements for the use of existing authorised secure accommodation via the SAN to operate those arrangements in accordance with the Concordat, as subsequently supplemented by the London Protocol, and to make arrangements to pool its resources with 3 other London boroughs to provide an out-of-hours response. And she goes on to say, the procedure squarely faced up to the practical impediments to providing secure accommodation in the case where a child had to be transported in the middle of the night and then brought back for a hearing in court the next morning. First of all, we say that those practical impediments, there's a total circularity. When the closest accommodation you potentially have is in Hailsham, and in fact, in reality, the closest accommodation you have is in Lincolnshire or Manchester, of course there's a practical impediment to providing secure accommodation because a child will always have to go on a 6-hour round trip in a very short window of time. That's precisely why the answer is always no, and precisely why Lord Justice Newgee, when he granted us permission, was right to say that the evidence may suggest that there's a practical impossibility. The evidence shows that the answer is always no. Now, when it's said it's rational for Waltham Forest to enter into centralised arrangements through the SAN, we're not disputing Waltham Forest entering into centralised arrangements for the SAN. The issue is that in entering into the SAN and relying solely on 15 units, 14 of which are operated by local authorities quite some distance away, and 1 of which is operated by a charity quite some distance away, and relying solely on those 15, that is inadequate. There's of course no problem with using a referral system for the SAN, and often for other types of placements for secure accommodation, welfare, or sometimes criminal justice, children are placed at quite some distance from home. You see that from Amanda Gordon's statement too. That is not adequate for discharging their obligations under Section 38(6) and meeting their gateshead duty. That is not a reasonable system. And that alone is not a reasonable system. And the Concordat and the London Protocol don't assist, because the Concordat and the London Protocol are about the principles. They don't actually deal with the practical impediments, the geographical impediments, which are the result of the failure to grapple with this issue. Now, similarly, paragraph 82 of Lord Justice Davis's judgment says, the sharing arrangements put in place cannot fairly be described as unreasonable in the public law sense, even if in some cases they demonstrably cannot achieve the ideal. Now, in some cases they demonstrably cannot achieve the ideal. That's precisely something which might meet the Gateshead test. You can have a situation like you had in Gateshead, where you have 5 requests a year, some of them can be met, one particular occasion they can't be met, there's reasons for that, it's explained. That is an example of some cases demonstrably cannot achieve the ideal. But that's not the situation here. This is not, it's a mischaracterisation to say Waltham Forest has a system which in some cases cannot achieve the ideal. In all cases, or almost all cases, zero evidence of any case being decided the other way, they do not achieve the bare minimum. So it's just a mischaracterisation of it there. And of course it's right that important issues of resources and allocation come into the equation here. The courts must show an appropriate degree of respect. But if this is not a violation of the Gateshead duty, we struggle to see what could ever be a violation of the Gateshead duty, frankly. And you then get at paragraph 83, the circularity point. And we're very sympathetic, of course. I'm instructed by an organisation that works with children in the criminal justice system and is very alive to the real world points made by my Lord Justice Singh earlier about children not getting a hot meal, children being placed in this dire position. And we are entirely sympathetic to that. We're very sympathetic to the point that's made in paragraph 83. The issue is that paragraph 83 is a circular point given the current arrangements in place from Waltham Forest. Now this ties in to a number of questions that arose earlier this morning, and I'll just run through these very quickly.
Speed through those.
Yes, I think they've mainly been answered, in fact. So first, my Lord Justice Singh said, let me just take them in the right order. Yes, the real world point. And thinking about the ramifications for children like AOR who are affected by this. We make 3 points on that. A, in the real world, it sometimes is not in the best interest for the child to be transferred. That's reflected in the concordat in that passage, which I went earlier. It's also reflected in a point which my lady made earlier. So of course, in some circumstances, it won't be in the child's best interests, and you don't transfer, and a decision is rightly made not to transfer in the child's best interest. It's impracticable under that category A. But B, at the moment, there is zero option and zero chance of a child being transferred under section 38.6 from Waltham Forest. So when it's in a child's best interest for them to be, in line with the statutory objects and purpose and the presumption, in local authority accommodation, they simply can't under the current system. And then the third point is, when you look at the statutory purpose and you look at the view Parliament has taken overall, while there may be some instances in which a police cell will be the least worst option, they must have a system in place which recognises that Parliament requires them, looking at paragraph 43 and 48 of Gateshead, to have a system which recognises that in most instances, children should not be in a police cell, they should be in local authority accommodation. And the system doesn't currently reflect that. So next question was, I think these aren't quite in the right order, but I'll just make sure I've got them. If the Court of Appeal says the system is unreasonable and Waltham Forest make an application for funding under section 82 and it's refused, even if the system remains unchanged, does it suddenly become transformed into a reasonable system? And that's a very fair question. I'm afraid the short answer is it's fact sensitive. Our submission is that when considering the reasonableness of a system, relevant factors will be both the current provision and the steps being taken to address any shortfall. You see that from Gateshead, where there have been a recent change and steps are being taken. The question is the system currently operated by Waltham Forest a system which no reasonable authority could adopt, bearing in mind the statutory test, the statutory objects and purpose? That's how it's described by Lord Justice Dyson in Gateshead. That's a high threshold, and we say we meet it. We say what is not reasonable is to proceed on the basis this is for others to deal with, it's for the SAM to deal with, and you rely on that when it's grossly inadequate for London children, including Waltham Forest children. And I've 3 more questions, and then one ties into the relief point, which I'll do extremely quickly. If the court says the current arrangements are irrational, my Lord Justice Singh asked, would one consequence be a reduction in welfare placements? And can I make 4 points on that very quickly?
Well, Ms Gallagher, I'm sorry to cut across you, but I am now extremely concerned for Mr.
Yes,
Underwood.
apologies.
And if you're now going to do 3 more questions, each with 4 points, I'm afraid that's just going beyond fair.
I can reduce this to writing. We do have answers to all of those questions. Should I finish this question and then just tell you very briefly our point on relief?
Yes. Well, I think let's just do relief, shall we? Please. Yes.
I'm happy to do that.
I know that I'm grateful that you've taken instructions, and I know we asked a lot of questions, so I'm not being critical of you.
And I'm very happy to reduce them to writing.
So just let's hear about relief very quickly.
Thank you. So on relief, of course, relief. I was asked by Lord Justice Singh earlier if we need to bear in mind that this is not a first instance decision and what's the basis for interfering with the discretion of the divisional court. And our answer to that is we've challenged the exercise of that discretion in ground 4. We deal with that in paragraph 7.12 to 7.13. So this is precisely a case where we say the exercise of that discretion was a flawed one. And this is a case where in our submission it's appropriate for the court to grant declaratory relief. And the baton then passes to the local authority to consider how to prioritise its resources. We recognise the prioritisation of resources, the potential knock-on effects and the mosaic on others is a matter for the local authority, not for the court. That's precisely why we've sought declaratory relief rather than anything more robust. And I'm happy to address any other issues in respect of relief in response to my learned friend's questions. My lady, may I just ask, on some of the questions from my Lord Justice Singh, we do have detailed answers. Would it assist if we reduce those to writing later on today? I don't want to be unfair to my learned friend. We're happy to do that, if that would assist.
Yes, please. Yes.
Thank you.
I think Lord Justice Singh would be grateful.
Thank you very much, and thank you for the indulgence of a few more minutes.
Thank you. Yes, Mr. Underwood.
My lady, my lords, I can be relatively brief, bearing in mind how much has been opened very fairly. Can I take it in this order to show you some of the actual evidence of the demand on this actual borough for PACE referrals for secure accommodation, as opposed to a blizzard of statistics and generalities. Secondly, look at a little detail of the system in place for responding to that demand. Thirdly, to look at the evidence about the capacity to meet that demand in Waltham Forest. Fourthly, to consider whether the law requires more of Waltham Forest. And fifthly, to respond shortly to the criticisms of the judgment below. My lady, starting with demand, there's a snowstorm of statistics born out of the various FOI requests, but there is in fact one set of useful statistics to do with Waltham Forest, and it's for one period, the first 10 months of 2019. What that demonstrates is that the Met Police made 9 requests for secure accommodation in that 10-month period of my local authority. And of those, after negotiation, it was agreed that 4 of them were not in fact properly requests for secure accommodation. And those 4, which were agreed to be requests for non-secure accommodation, were met. So ironically, you find yourself evidentially in almost exactly the same position as this court did in Gateshead, with 5, statistically, 5 applications for secure accommodation in a period, in that case, of a year, in this case, 10 months. The reference for that is at pages 423 and 425. It's in the witness statement of Sergeant Bullivant. We can look if necessary, but that's the clear evidence. So that, of course, is the high point of the case against Waltham Forest in terms of demand. That doesn't mean that those were proper demands. in the sense that each of the 5 proper requests for secure accommodation were practical requests. And having gone round the houses, your ladyship's now been given the agreed definition amongst the Home Office and local authorities about what impracticable includes, and it includes not starving or depriving a child of sleep. And so in terms of practicality, one simply doesn't know of those 5 requests, what time of day they were made, how far away the police station was in which the child was, etc. And if one thinks about the practicalities of that, not only does one have to consider the time of day, or know the time of day in which the request was made, one would need also to know whether the child was already looked after. Because it's only if the child is already looked after for an overnight request that Section 25 is triggered. And Section 25 therefore involves the local authority in a separate set of considerations. And also, if the child is known to the local authority, looked after or otherwise, whether that child's going to have files, which is going to mean the out of hours social worker finding the files and considering them, particularly in Section 25 cases, to see whether there's agreement with the police about the need for secure accommodation. Then, we know, and we'll look in a little detail about how the processes work, under the scheme which Waltham Forest and 3 other authorities have signed up to for out-of-hours duty social work, a social worker must attend the police station in every case. So, again, it's very important to know where in London, relative to where the social worker is, out of hours, the police station is, and the child is, so that that social worker can get there. And all of these are factors which play into not just the simplistic question, what time is the request made and how far away is the accommodation? There is a whole process to go through before the very important principle of the local authority taking responsibility for detention. The legal power and duty of detention transfers to the local authority if secure accommodation is provided. So there's a very formal handover, very formal and important responsibility, including a responsibility, of course, to get the child to the secure accommodation and back again to court the next day, all of which has to be organised.
Well, Mr. Rowell, you may be coming to this, and it may be that I just haven't seen it. But as far as I can see, we haven't been told where the areas are that they can be sent. We don't know from the local authority which are the secure units which they deal with and where they can send some.
No, you don't. That's perfectly fair. All we know.
It's pretty fundamental.
Well, of course, my lord. And that's.
I mean, if it's 200 miles away, it doesn't matter a damn how long you have talking to the sergeant, for example. It really is a completely wasted exercise.
Well, this may go to the very key issue in the case, in our appreciation of it. It's the question of whether a PACE request can ever be met by Waltham Forest for secure accommodation. And the short answer is, overnight, probably not. On a weekend, yes. Because if it's 200...
how far you think it's appropriate for a child to travel for a weekend.
Exactly.
200 miles, 300
Perhaps.
miles?
Yes, it may be.
And that's deemed to be appropriate by your authorities?
It's deemed to be appropriate by this court in Gateshead. So yes.
Hull to Gateshead.
I'm sorry?
Was it Hull to Gateshead?
No. Well, I'll come to it, but if you look at the...
overnight, no.
Overnight, no.
Weekend?
Weekend, yes.
Even if it's 200 to 300 miles?
Yes, because that's not going to deprive the child of sleep or food, so it doesn't meet the impracticability test, if you like. I'm not advancing this with any degree of pleasure. These are straitened circumstances and difficult areas. So, just looking back at demand for the moment, rather than supply, the high point of the case against me is that in that one period for which we have statistics of 10 months, 5 actual requests for secure accommodation were maintained and not met. But we don't know of those how many it would have been impracticable for them to be met anyway.
But we have to bear in mind that there were 9 requests.
Yes.
And some, no doubt, skillful negotiation resulted in 4 of them being dealt with other than by way of secure.
That's correct. Well,
So it's
nine requests.
Not 5 requests.
9 requests, 5 of which were maintained.
Yes. I'll go for that.
This is the way I sought to put it, and perhaps didn't put it loudly enough. Then can we look at the system? It's decried as being a good system for saying no. It's much more than that. It involves, of course, access to the SAN. So one of the reasons why it's very difficult for Waltham Forest to come up and say, here's the evidence of what's available at any given time, is that it subscribes to this pooled system, and it relies on the pooled system. The EDT process, if we can look at that for a moment, is at page 312 onwards.
Sorry, this is in the supplementary bundle.
Yes, please. So this is the specific agreement between Waltham Forest and the 3 other neighbouring boroughs. And at 3.1.9, children in custody, when the EDT service receives a notification of a child in custody, the on-call practice manager will be notified by the EDT senior social workers on shift. And then in cases where children have been charged and denied bail and are remanded in police custody, the EDT senior social worker is required to visit the child and assess their health and welfare and offer support. And then 320, PACE, going over the page to 313, second paragraph, as a guiding principle, it needs to be understood that police cells are not a suitable place for children to be. Therefore, wherever possible, charged children should be released on bail. A night in custody can be intimidating, etc. Therefore, you are expected to provide local authority accommodation. Please follow the guidance below. And it sets out a number of things. The 4th bullet point is the type of accommodation required is for the local authority to determine, bearing the custody officer's views in mind. So again, I take your ladyship's point about 9 requests, but the request is just the request. It's the starting point for the obligation for the local authority.
So is this right? I'm surprised. Maybe it is. The type of accommodation is for the local authority.
Yeah.
I thought it was for the police sergeant to determine whether or not it should be secure accommodation.
It's for the police sergeant to determine whether he requests secure accommodation.
Yes.
And it's for the local authority, under its Section 21 obligation, as foreseen by Gateshead, to determine, first of all, whether that's right. Because its obligation is a matter for its decision. And that's not just true under Section 25, where it has a completely, a different test to the police. Its obligation is its separate statutory one.
So when you call that negotiation, you mean, in fact, that the local authority is taking possibly a different view or possibly persuading the police sergeant?
Yes, and the reason I call it negotiation is, I may be shorthanding it, is what Sergeant Bullivant very fairly says.
I'm happy with the word. I just want to clarify that's what it is.
I attempt to précis Sergeant Bullivant's evidence about what's been happening on the ground. But yes, as a matter of law.
So when under Section 21(2), it says every local authority shall receive and provide accommodation for children whom they are requested to receive under Section 38(6).
Yes, that's right.
I've misunderstood that in presuming that meant that your obligation was to provide secure accommodation. Your obligation is to decide whether you will provide secure accommodation.
No, my lady. The whole point of Gateshead is that the obligation is to take the child or offer accommodation for the child. What accommodation is offered is a matter for the local authority. And Gateshead said there is no obligation to provide secure accommodation. The obligation is to consider what sort of accommodation.
And to have a reasonable system.
Exactly.
Which is capable,
Yes.
in principle, of responding yes.
Oh yes, if you decide that secure accommodation is the right answer.
Does this guidance say anywhere what you've said to this court today, which is that the practical reality is that if your request is made during the week for overnight accommodation, it will not be available.
But there's no evidence that it would.
Yeah, but this says,
Sorry, go
if
on.
my lady will forgive me, this says, as a guiding principle, it needs to be understood that police cells are not a suitable place for children to be.
Yeah.
It doesn't say anywhere, does it? But the reality is that if you make your request during the week rather than the weekend, we shall be saying no.
No, it doesn't say that. No.
How can that be regarded as a reasonable system for
Can I
having
just-
in principle something available during the week?
Can I descend to the facts? Here, this boy was remanded overnight before charge, then charged, then the request was made of the local authority to provide secure accommodation. The first answer to that the local authority came up with was, we can send him back where he was, or, because the police concern was that if sent back there, he might exact revenge on one of the complainants, the local authority could send him to a different non-secure place in a different part of London so as to avoid the retribution. So it was seeking to avoid him being in the police cell.
But it was also seeking to avoid secure accommodation, because on the facts that we've got about what this young man was up to, it might come as a big surprise that anyone thought that it would be appropriate to send him to his old children's home where insecure and where he'd kept his knife cache, presumably without discovery to date.
Yeah, I'm not complaining that the police made the right call.
No, but the local authority's response was, well, let's try non-secure.
Yeah. The local authority's response was, let's get him out of the police cell. And the complaint being levelled at me there was, the local authority is not actually paying any real attention to its proposal to keep children out of police cells. But there are alternatives to secure accommodation.
No, I understand that, but you have to contemplate a scenario, as Gateshead, I think, does, that there will be some cases in which there is a need for secure accommodation.
Yes.
And the only realistic alternative to that is overnight in a police cell.
Yeah.
And I don't want to oversimplify the position, because that would be wrong for all concerned. But the reality of this local authority's position appears to be that the probability is that if that scenario arises on a weekday night, the request will not be capable of being complied with.
Yes.
Right, and that's very fair. That's a very fair answer.
Well, I can only be candid with you.
No, yeah, that's very helpful to be candid. And the question ultimately for the court is going to be whether that complies with what Gateshead described as a reasonable system.
Well, I gave this in answer to Sir Patrick and said, I apprehend this is the key issue.
But can I ask you in connection with that? You say we're being candid, and you are indeed. Laudable. But I have to say, I'm very troubled by the evidence that the local authority hasn't put forward in this case. It's meant to be a cards on the table approach to this kind of case. As Lord Donaldson said over 30 years ago, you've relied upon these 9 cases, which are the only 9 that the claimants have been able to discover. But why hasn't the local authority said, look, this is our system. These are the number of cases we've had in the last 5 years or however long. Or said, it's so difficult to find out, I'm sorry, we can't really be very helpful about this. But we've had, really, I think it should have been for the local authority to say, this is what's been happening. In the absence of that, why shouldn't we say 440 across London, only one of them's ever been given? Why should we make any assumption that Waltham Forest would be in a better position than that?
Well,
Because there's no evidence.
perfectly fair question, but there are 2 components to it. The first is whether Waltham Forest has failed to put its cards on the table. It hasn't failed to do that. Buried in this evidence is a couple of answers to FOI requests made by the other side of Waltham Forest, in which Waltham Forest said, we don't have records for this. Requests are made orally, they're determined orally. We don't have a paper trail.
Were the requests made during the currency of the proceedings or before the
Before.
proceedings? As a precursor to the proceedings.
And secondly, should one extrapolate from that the worst case should be held against Waltham Forest? No, with respect. The statistics are the evidence which is in the case.
Well, one snapshot of 10 months.
It is. That's the evidence there is.
Speaking for myself, Mr. Underwood, it may be ultimately crucial, but speaking for myself, can I just tell you what's causing me concern? Whether the number is 5 or 9, what really concerns me is whether this local authority has a reasonable system in place, so that should the scenario arise, it is at least capable in principle of meeting it.
Yes.
So whether it's 5 or 50, 5 or 9, if it's only one, but actually there is no system in place which is capable, at least on weekday nights, of meeting it, I wonder whether that can really be said to be a reasonable system.
Yeah, I'm going to have to come to the law, and I'm endeavouring to do this in an order, which I'm now completely out of. I was looking at demand. I was looking at the system.
I don't want to take that to order at all.
It's my fault for rising to questions rather than simply parking them to an hour or two's time. So the system is what I just described, and of course you know. The protocol, of course, is also part of the system, but what can't be said against this authority is that it pays no attention to its legal obligations. Whether it meets them is the critical question, not whether it pays any attention to them.
Whether it's capable of meeting.
Yes, quite. There are straws in the wind about this, and they are all on page 212 of the supplementary bundle. Can we look at that? This is the first statement of Amanda Gordon. And it deals at letter D, 2/3 of the way down the page. Well, sorry, I should start at the top of the page. There is one instance of a child being accommodated in secure accommodation the same day as the application was made. And that's child N. It's not a PACE referral, but in principle, that demonstrates that it is possible to accommodate somebody the same day. And then if we look at letter D, there's a period of 18-20 months dealing with EDT workers receiving 17 requests for PACE secure placements, and EDT workers made inquiries with the secure children's homes. None of the children were accommodated in the end. The reasons were A, non-availability of placements, B, bailed back to family, C, remained in custody as per decision. This was the most suitable option based on the context of each case. D, only in 4 cases a place was identified. The home was located too far away from London, and it was not practically possible nor in the child's best interest.
But Mr. Underwood, I'm not going to keep interrupting you, but this is exactly the point Sir Patrick's made. You know, non-availability of placements. Well, was that 16? 10? 1?
We don't know. No, and neither do we know. And again, this is a record-keeping problem, which puts Waltham Forest in the difficulty of not apparently putting its cards on the table because its cards aren't in its hands. We don't know whether non-availability means, for example, that a children's home applied to didn't take PACE referrals, or that it was full.
But doesn't it go to the reasonableness of its system?
I'm so sorry.
But arguably, could it not be said that this failure to know what on earth's going on your patch goes to the reasonableness of your system? Because if you don't know what's going on, and therefore you don't know what your needs are and the deficits or other in it, how can you say that the system in place is reasonable?
Well, if that had been put before the divisional court and it was made of a criticism of their judgment, then I'd take it. It's first emerged here, which is not the place for it to emerge with respect. However substantial it may be as a point.
We don't know, do we, the nearest secure unit?
No.
The whole thing is very unsatisfactory.
It's the difficulty that the other side, if I can put it that way, has been accumulating evidence over years and has come to the head of bringing this case. Waltham Forest was one of many people it asked, organisations, of whom it made FOI requests. It wasn't put on notice that it was going to be needing to meet.
It knew the challenge was a reasonable system. I mean, it wasn't like they turned up on the morning and were told this is the issue.
Milady, I see the force of that, and it has some force.
I hear your response.
Yeah. Can I then turn to what the law requires? We're in some danger of treating Gateshead as if it were Holy Writ. And that should be avoided, I respectfully suggest. The way in which Lord Justice Dyson in particular engaged with his, if I may say so, typical thoroughness with the question is impeccable. This is a matter of statutory construction. As I endeavoured to say a while ago in response to Milady, there is no obligation explicit in the Children Act to supply secure accommodation to any particular request. The obligation is to supply accommodation. And as Lord Justice Singh put it, that has to allow for the possibility of supplying secure accommodation when apt. The question is, what do we mean by allow for that? What is the range of reasonable responses open to the local authority? And the first thing to knock down, which paragraph 44 of Gateshead did, was the notion that that requires even reasonable endeavours to have secure accommodation available. And if we see what the court meant the threshold to be, you see what happens on the facts. And if we could look at it briefly, tab 8 in the authorities.
I was reading paragraph 44.
It's paragraph 54 I was going to go to.
Of Gateshead.
I'm so sorry.
Are you in Gateshead?
Yes, please, I'm so sorry.
54.
Lord Justice thought delivering a concurring, if avowedly more robust judgment, sets out something which is not an analysis of the law that's different. It just simply refers to some facts which don't emerge so clearly from the rest of the judgments. Paragraph 54, just above F, on the right hand, about the middle. Thus, unless the PACE request were received on a Saturday or Sunday prior to a bank holiday, the length of the return journey effectively precludes Gateshead's use of Hull. So the accommodation which was available could not have been accessed on a weekday. And yet it was still lawful.
So it does seem from a little further up that there had been this place, Kylo House, which had been able to offer it, and that designation had been withdrawn.
That's right.
Now, we don't know, well, maybe we do elsewhere in the judgment, how long beforehand did it
Well, materially, it's the Gateshead, the Hull property that was available. So, yeah, historically there had been another one.
Well, it may matter, because, I mean, if it's mattered 6 months beforehand, that happened, it's going to take the local authority time to deal with it.
Yes, I
If it's
think
been there for years, it might be rather different.
I think the difficulty with this, as Lord Justice thought made clear, is that this came out of discussion with counsel rather than the evidence. So, but what you've got is that on the facts, unless the PACE request were received on a Saturday or Sunday prior to a bank holiday, the length of the return journey effectively precludes Gateshead's use of Hull. The policy of ensuring that young persons are not held in police stations when other accommodation could be made available is obviously laudable. However, where that other accommodation must, in the circumstances of the case, be secure, the distinction between a night in the police station and a night in secure accommodation is not so stark, since both involve a deprivation of liberty. So it's a good indicator of how the court applied the test, and therefore what the test was, threshold was set at, to see how this court thought that Gateshead had complied. And in truth, it's an impossibility test. Although it was put in two ways, and Lord Sir Patrick put it as difficult to discern how they could be different, or how they could both apply. In truth, where you've got an obligation to accommodate and a discretion about how you do it, in these circumstances, it is difficult to see, and where it's not an obligation to use reasonable endeavours even, let alone best endeavours, it's difficult to see more than an impossibility test. And that's actually compatible with the Supreme Court's latest discussion of the interplay between the executive, the legislature and Parliament, the executive and the courts, in Begum. And I don't want to attempt to use Begum more than is apt, but there was recourse back to what Lord Hoffman has famously said about the constitutional divide. And one of the points arising out of Begum is that the court is very often not in a position to understand all the nuanced information available to a local authority or a decision maker. And it's Lord Justice Singh's mosaic point, that very often the court is faced with a part of a mosaic, and you say, well, of course, obviously, it doesn't matter, even if it's only one child a year, you've got to make accommodation available to it. Well, how? What does it take? We don't know. And that's the constitutional difficulty.
But there must be a limit to that.
Yes, there must.
Because it's Parliament that said
No,
that one should avoid having kids in.
I entirely accept that. And that's why I say it's the impossibility test. Because that's clear. If it's impossible for a local authority ever to take a PACE secure accommodation request and accommodate the child accordingly, then it clearly can't be meeting its obligation. Anything less than that won't do, because the court's not in a position to say what should else have been done.
Are you saying that's what Lord Dyson is saying in paragraph, or Justice, paragraph 48?
I'm saying that's what he was saying when he said only if it's impossible or alternatively.
I'm not sure whether he is saying that. I'm wondering whether he's saying...
Was it 42?
48?
I'm sorry, I've lost it again now. It's 48, yeah. Letter G. In my view, they should do so, that is, interfere, only if satisfied an authority has made no arrangements at all, so they can never provide secure accommodation when it's requested, or when the arrangements have been made are ones that couldn't have been made by a reasonable authority.
Yes. See,
Really, those things have to mean the same thing.
Sorry, you said they have to mean the same thing?
Yes, because...
Well, actually, I think that what he's saying is, on reflection, that if you've made no arrangements at all, then that's plainly in breach.
Yes.
If you've made arrangements, it's still in breach, if they're not arrangements that a reasonable authority could make.
And I would add a rider to that, so that they could never actually provide
Well, I'm
accommodation.
not sure why that I'm not sure that rider is a legitimate one.
Well,
there we are. You can argue.
Obviously, you're quite right to remind us that no judgment should ever be read as if it were a statute. Fine. But this isn't really anything new, if I may respectfully say so. This is just the application in this context of classic Wednesbury principles. And that formulation that the arrangements are ones that could not have been made by a reasonable authority is Wednesbury. That's irrationality, as we today call it. But it's in the important statutory context context, as the next clause says, mindful of the need to avoid having children detained in police cells if at all possible, because that's Padfield. Lord Justice Dyson has already said by this stage of his judgment that Padfield applies in this context.
Fair point. But can I go back a stage further? That we are
Yes.
discussing a discretion
Certainly.
afforded under statute, which is informed by the statutory context, which therefore triggers Padfield.
Absolutely. There's no duty. As you say, there's no duty even to use best endeavours. There is a discretion. But well, again, forgive me for saying something very, very obvious. In public law, there is no such thing as an absolute discretion, an unfettered discretion. All discretions are limited by the object and purpose of the statute, and they have to be exercised reasonably.
Yes, but again, we can't ignore the fact that the court has found there isn't an obligation to use reasonable endeavours.
Yes, I understand.
So one has to read that passage in paragraph 48 subject to that.
Yes.
And again, I have a grave risk of Talmudic analysis of this. In the end, it's a discretion, it's Padfield. And the court's difficulty is the classic difficulty where you simply can't get all the picture. And the constitutional divide. This is not a yes-no type of decision. This is resource, it's political.
Well, you say that, but this is an unusual context, at least in my experience, where there is the opportunity to obtain funding from central government. And one of the criticisms made, you may be coming back to this, I don't know, is that you haven't demonstrated that you have acted rationally if you haven't yet tried to apply for funding and then see what they say.
Yeah, this is where our fresh evidence comes in for what it's worth. I'd say this goes to relief if you're against us on the case, that by the 6th of July, there will be an application for funding for the 2 units for PACE accommodation. That is the evidence. The Secretary of State's got it wrong in not understanding that, because, of course, the application's not got in yet.
Where have we got the evidence that the application?
That's the fresh evidence.
Well, as I say, I don't take anything out of order at all.
No.
So please do come back to this.
But that's, I've taken instructions over the lunchtime, and I've been told it is a misapprehension on the part of the government that the reference in the fresh evidence to the application for 2 sets of unit is not a reference back to an old
the June
formulation.
19 document.
Yeah. I haven't seen any more than that. And it, as I say, it's a question for relief. It's no answer to this claim, of course, because as at the date of this claim, that application was not in being.
I'm sorry, I shouldn't remember this, but I've forgotten. Is it a pure Waltham Forest application, or is it?
No, it's not.
It's the consortium you're in, isn't it? Yeah, that's right. 4 or 5 local authorities.
It's more than that. It's the London councils, I think. So it's the totality of the London boroughs getting together. And
Right, so all 32 London boroughs.
I see.
that's my reading of what Clive Grimshaw says in his evidence about the London councils and what this evidence suggests.
For myself, if it's not already available in the documents you've supplied, if what you're saying is not clear from the documents, but you are able to confirm that these applications have been made and they include whatever units there are, then I'd like that in writing, actually. It'd be helpful to have that.
Of course, what I'm told is that 6th of July is the cut-off date for these applications to be made, and it's intended that they will be made by then. So that's the reference in the...
6-7 days away.
Yeah, quite.
Presumably there's a draft.
Yes, well, assuming that Waltham Forest has a copy of the draft, it shall be obtained forthwith. But if it's in the hands of the centralised,
Understood.
then of course we'll have to get it from them.
Because looking at your, not your,
Yes,
sorry, the
I stand by it.
the new the Secure Children's Homes Capital Programme. Looking at the application form, application form. This seems to me, I'm sorry, I'm just having a moment here where I've forgotten the date of the hearing.
Yeah, so this is
Okay, March 20 was the date of the judgment, and the hearing was February, 26th of February, all right? So the application form, we're told, is for projects to start this year. Time frame, detailed scope of pre-construction work, costings, time frames, etc., etc. Project need, delivery, cost, completely worked up business case, effectively, to use civil service speak. But where was the court told, or where has anyone been told? Don't worry, it's all in hand.
no,
We've got this huge piece of work going on. We've got a committee, 3 subcommittees, and we've got our scoping and we've done our costings, and here it is.
nowhere.
And there's never was and never has been any evidence about that.
No, my lady, and I hope I made it clear that this only, in my submission, goes to relief. It can be no answer to this claim that there is now in place a request for funding, or there will be in place sometime soon a request for funding. It may well go to relief if we get to that point. I see that. I'm not praying it in aid in any sense as an answer to the case.
All right, thank you.
Either it's good enough that there is a pooling which can provide secure accommodation at a weekend, or it isn't. It really is that simple.
Pooling can provide accommodation at the weekend, but not within the area of the pool.
Oh no.
So you're saying it's good enough that there's a route that you can go to for a referral.
As long as it can provide
in a different
accommodation
part of the country.
in some circumstances, yes. What can't be right is to say that this has to be accommodation in Waltham Forest.
No, I wasn't saying that.
That I understand, but could it be formulated in the following way, that it must be within a reasonable distance of the courts?
It could be. The difficulty with that is you have no idea what the court is. This case, for example, is a case where the application was made to Waltham Forest by a police station in Lewisham.
I see that.
And so the difficulty with that formulation is, let's take what happens with county lines, that you're going to have children who are in trouble all over England and Wales.
Yeah, I entirely see that. But what would be wrong with the formulation along the lines of must be within a reasonable distance of a magistrate's court? So deal with the problem that it's not in your own area, but at least you can get them to a magistrate's court.
I'm sorry, I don't see how that works. Imagine the police station in Swansea charges a child for that child to appear in Swansea Magistrates Court the next morning. It's no good me having accommodation near Waltham Forest Magistrates Court.
The real problem as I see it, and do correct me if I'm not seeing it correctly, but I think what the appellant is really complaining about is that on the evidence before the court, the reality is that in the whole of London, with however many courts it has, the whole of London is not served by anywhere that is within a reasonable distance of any London court.
Yes.
That's the problem.
And then they complained that the divisional court said this was a problem wider than Waltham Forest. One needs to be very careful about what case is here against Waltham Forest and what the divisional court got wrong about that. And the answer is the divisional court got nothing wrong about that, because so far as Waltham Forest is concerned, the evidence is that there were 5 maintained applications for secure placements in the only statistical period we've got covered, that there is capacity to find accommodation, certainly for weekends. In the past, there has been accommodation found within 24 hours, certainly, so that it's not impossible to accommodate. And those were the boundaries within which the Divisional Court was entitled to act. And it's so easy to run off into thinking this is a serious nationwide problem, which it is. One can't avoid what Re B says. This is a serious nationwide problem, not just concerning PACE placements, but concerning secure children's homes. And whether or not you regard it as a governmental financial problem, it's irrelevant. It's nationwide, it's certainly London-wide. This is a borough, in common with many other boroughs, who's taken a particular course. You've seen in the judgment a discussion there was with me, when it was put to me, well, just because this borough does what other boroughs do, that can't make it right. But it's a powerful indicator that if all boroughs are in this position, or pretty much all boroughs in London and pretty much all boroughs across the country, it's very difficult to say that's irrational.
Well, it may just mean that they all think they can't afford to comply with their statutory obligation. Maybe they can't, but you have to find a way.
But what the Divisional Court was being asked to say was, what this borough does is the same as everybody else, and it is all irrational. And that's a very ambitious.
I'm sorry, I don't have any difficulty conceptually.
No.
That could be a good submission, depending on the merits.
It could be true.
Yeah. It could be that, whether for financial reasons or other reasons, all public authorities in a given area of human life are failing to comply with their statutory duties. Yes. And if they are, then the court should say so. If they're not, then they're not. No,
quite. It's what I've always characterised this case as being. It is a generalised challenge focused on one local authority.
But it has to be, it has to be focused on one local authority because the obligations are individual.
I'm not complaining. I'm just bringing into stark relief the notion that this is in truth a challenge which can only succeed if every local authority who is in the same position as Waltham Forest is also acting rationally. And
there could be a distinction. It may be that one or two have sought to get money, public funds, and haven't.
It's possible, but the evidence is that all the London boroughs,
but it could be that it's the London consortium that effectively, if I can call it that for shorthand, that you would say are all in the same boat, but clearly because they're all acting in concert, that you can possibly comment about any other local authorities outside of that consortium.
Though, in truth, if one... And let me come to this in terms of the criticism of the judgment. When the Divisional Court described the complaint as being nationwide, as it were, that's fair on the evidence. And if we look, please, in the supplemental bundle, the way the evidence supporting this application is put, we started at page 9 in the supplemental bundle. Paragraph 3, I explain in this statement a number of matters which relate to this claim, both generic issues concerning the detention of children in police cells and certain issues arising which are specific to AR. In other words, the distinction isn't between Waltham Forest and AR, it's between detention of children in police cells generally and AR. And if you look at paragraph 5 then, the prevalence of the overnight detention of children in police cells has been a concern of the organisation for some time. And then it refers to the Children Commissioner letter. Paragraph 6, further we're aware of a number of reports highlighting this issue, National Association of Youth Justice. And again, if we look to the criticism of the Divisional Court for finding that this was in truth a complaint about nationwide provision relating to governmental financing, just look over page 10. The citation from JDT3 is a citation within a citation from the British Transport Police. For juveniles detained after charge, the section relating to finding secure accommodation before court should be removed, as no council can ever provide such accommodation.
I'm so sorry, I've lost you.
So, top of page 10.
Thank you.
It's the italicised part. It's a citation from the National Association of Youth Justice, which itself cites the British Transport Police. So that is, no council can ever provide such accommodation. This hasn't always been the case. Long-serving youth justice practitioners consulted confirmed that prior to the reforms introduced by the government in 1998, failure to transfer to local authority accommodation was rare. So the case has been put throughout on the basis that this is the tip of an iceberg, and that the evidence, all of which I haven't taken you to, is nationwide. So you are being asked to say no authority acts rationally about this, save perhaps those 14 or 15 who happen to have children homes.
Although I think the freedom of information requests, am I right in my recollection about this, that they were only sent to London?
They were...
The freedom of information requests only went to the London Borough.
Yes, it's paragraph 11, page 11.
They did, yes.
Thank you.
Yeah, so the focused evidence then, which has statistics in it, is London-wide.
Mr. Underwood, I understand, I don't want to be too pedantic, but a problem could be nationwide in the sense that it's a problem which occurs in all parts of the nation. That doesn't necessarily make a national problem in the sense of it being a central government problem. Because, as my Lord has said, the statutory duty is imposed on every individual local authority.
I get that.
So if there's simply, as it were, a conglomeration of many local authorities which are in fact in breach of the statutory duty.
It's not central government's fault.
And I think, I know you're going to come back to the grounds of appeal, but I think ground one of Ms. Gallagher's appeal is that the divisional court fundamentally misunderstood what the nature of the problem is, because they thought that the problem was at the national level and arose from a lack of government funding.
Yes and no. Can I come back to that in a minute? Can I simply say one more thing about the notion that on the evidence there are so many authorities in the same boat as Waltham Forest, and therefore you can properly find they're all acting irrationally. This is very much like a test of negligence. If everybody does it, it would be very difficult to say it's negligent. And if local authorities as a whole, all of whom direct themselves, according to their protocols, their EDT processes, etc., direct themselves to their statutory obligations and have them in mind, for this court to say, contrary to what the divisional court said, you cannot regard that as a rational conclusion, is going very far. And of course, I understand, in principle, there's no problem with that. I mean, the appellate courts are always finding things to have been thought to be rational in the past by large numbers of people, which are in truth not. But I simply point up just how ambitious a claim this is. So far as the first ground is concerned, I accept that there was a misunderstanding in paragraph 29 of the judgment below about the funding stream. 2 points. First of all, that doesn't feed into paragraphs 72 and 80, which are the analysis. And secondly, in truth, the judgment of the divisional court was focused on whether this local authority could ever accommodate on a PACE request for secure accommodation, and whether in train with its centralised procurement, that was a sufficient system. And it's too much salami slicing to look at random passages and say, that's not quite right. Well, substantively, what happened here was the divisional court focused perfectly properly on the question, was this a reasonable system, therefore rational, therefore consistent with the Padfield obligation? And that's ground one. Ground two is a criticism of the finding that there was no material difference between this and Gateshead. In fact, there's no material difference between this and Gateshead, for what that's worth. There were 5 requests in a year. Here we've got 5 maintained requests in 10 months. Here we probably can't accommodate overnight, and there neither could Gateshead, as we see from paragraph 54. But it's not central to the reasoning in any event. Every case must turn on its facts. Then it's said at ground 3, you can't sustain Waltham Forest's system simply on the basis that it has a pretty set of processes. Well, of course not. If the pretty set of processes cannot provide accommodation, or what is a rational amount of accommodation, then it doesn't matter how pretty they are. Equally, if it can provide whatever the minimal rational level of accommodation is, likewise it doesn't matter how pretty they are, but in fact they are.
But in truth, from what you've been saying, it seems that the purpose of the system is not, perhaps as Ms. Gallagher says, to just go through an automatic sort of answer and say we haven't got anywhere, but rather is perhaps to try and take the view that a secure unit is not required. In other words, you might deal with it by saying there's no secure unit, but once a secure unit is required, then unless perhaps it's weekend, you've got no evidence about that, you accept that nothing could be done.
Yeah, that's what it is a short point. My friend was right in the outset by saying it's a short case. Then we get to discretionary relief. If you're satisfied that the court below went wrong on the substance of the matter, and therefore, in principle, the appeal should be allowed, that doesn't help you with whether its alternative conclusion that was also got wrong. Because obviously the question of what relief the court would have granted was in the alternative. And so what my friend's difficulty is there is finding a set of challenges to that alternative. And none has been advanced.
Mr. Underwood, can I just ask you this, and I don't want to be unfair at all, but I want to be accurate about how you're putting the case. Are you saying that if this court were to conclude in due course that one or more of grounds 1, 2 and 3 are made out, in other words, that the appeal should succeed on substantive grounds, that ground 4 simply wouldn't arise because that's on an alternative basis? Ground 4, as I understand it, is on the basis that even if there was no substantive error by the divisional court, its approach to discretionary relief was wrong.
The divisional court made a freestanding decision. If we're wrong about everything else, we wouldn't have granted discretionary relief.
Exactly.
So the ground 4 has to be a freestanding challenge.
Yes.
It has to.
But if we were to conclude that the appeal should succeed on one or more of grounds 1, 2 and 3, wouldn't the situation then be that we would have to decide in our discretion what relief is then appropriate?
In principle, yes, but where the court below has said
Yes.
that we wouldn't have granted discretionary relief, and where there is a ground of appeal attacking that,
Yes.
you're seized on it. And what my friend hasn't done is show you a discrete set of arguments aimed at that point, i.e., assuming that the divisional court was wrong on everything else. You can't just bring across its errors and hold it against the divisional court in relation to this alternative argument, or alternative conclusion. So the question is, faced with a divisional court which said that even if Waltham Forest was in breach of its statutory duty, we wouldn't, in all the circumstances, have granted discretionary relief. You're being invited to say that was a flaw. And there is no flaw in that. This was a court which had trawled through the evidence at great length, which had received all the submissions it received. This is very much a discretionary remedy. And no flaws demonstrated in its decision not to grant a discretionary remedy.
Well, I notice in paragraph 7, I would not have been minded to grant declaratory relief. I'm not sure how much weight, to be honest, one can give to this kind of alternative. It's not an alternative reason for finding it's not a...
No.
It's a kind of tentative expression of a view. And it's also in view of the steps taken by the London Council. So we have to review those steps for ourselves.
Fair enough. And
there's something rather artificial, actually. The court saying, look, you've not complied with the law, and then not giving a declaration. Even if I understand the court declaration has to be very carefully formulated so that it isn't any kind of mandatory obligation. But it's rather fanciful to have a judgment that says you acted contrary to law, but we're not going to give a remedy.
well, and again, it's no part of Waltham Forest's case to try to pull wool over anybody's eyes. When the court put to me, Mr. Underwood, if we're against you, what relief should there be? I said there should be a declaration.
Right.
Very
How on earth you formulate it, I don't know. And if we ever get to that point, against my submissions, that's when I apprehend you're going to need better evidence about what Waltham Forest and the other London councils are presently doing.
Which takes you back to your comment to me that the issue about evidence and so on goes to relief.
Yes, because this could, of course, have quite important consequences.
Yeah,
And I'm not here to suggest that the government is speaking nicely while keeping its wallet firmly in its pocket. But experience as a public lawyer suggests that having the power to make grants and granting them is another matter.
Mr. Underwood, I don't want to give the impression at all that any member of the court has any view, whether provisional or firm, about what the outcome will be of this appeal. Obviously, we'll have to consider everything that's been said. But just to be clear, are you suggesting that if the court were to reach the stage in its deliberations where it thought that the substantive grounds of appeal, or one of them, had merit, this might be at the stage where we distribute a confidential draft judgment in the usual way. Are you suggesting that that might be a point in the proceedings where it would be helpful for the parties to have an opportunity to put in further evidence?
Yes, please.
On relief?
Yes. Because the court's in an unenviable position otherwise. If you were to go away and write a judgment, including relief, let alone, or just go straight from writing a judgment to hand down short submissions on relief.
Yes.
Because, as I keep saying, the consequences for many other authorities could be important here, and it may well be, for all I know, that you may be completely satisfied on relief that the application being made on the 6th of July covers the ground.
Yes, we do sometimes in this court find ourselves in that kind of situation. It doesn't necessarily follow that an oral hearing is then required.
No.
It's often possible to deal with these things in writing.
No, certainly. And if I may say so, my friend's team has been completely consistent and straightforward about this, that they're trying to bring a problem to the attention of the court and get what relief is reasonable. And there's no reason to believe we're going to fall out about it if the evidence is clear. So, my lady, my lords, I've shot my bolt. Obviously, if there's anything else I could touch on, I'd be very pleased to.
Well, thank you very much indeed, Mr.
Thank you.
That's been extremely helpful. Anything in reply?
I'm shamefacedly rising to my feet, having said we'd be short and having been far longer. And I'm very grateful to my learned friend as well for being so candid. on a number of points which I think will help.
I've asked a lot of questions, and I apologise for that, but you've kindly addressed many of them, and you've also said that you will help me in writing with others.
Thank you, my lord, I will. There's a number of short points in reply. So firstly, can I deal with the statistics right at the outset? Because our submission, and I'll show you why, is that in fact the statistics you've just been given about Waltham Forest are not correct, and it's a misunderstanding of P.S. Bullivant's evidence. I am going to have to ask you to turn this up to show you why that is the case. I should say nothing particularly turns on this, it's not a numbers game, but I don't want the court to fall into error. So reference was made to in 10 months of 2019, there being 9 requests for secure accommodation, 4 in fact not being properly requests for secure, so it reduces to 5 in 10 months. That's not correct. You find this at page 423 and 424 of the supplementary bundle. Starting at paragraph 9. This is Police Sergeant Bullivant, Anne-Marie Bullivant, acknowledging at paragraph 9, this is an issue that met detention as a whole.
Sorry, can I just orientate
Of course,
myself?
it's 423.
And it was within the document really, I wanted to orientate myself.
Her statement starts at 422, my lady.
Okay.
And she made this statement to assist the court. You'll see paragraph 9 and 10, she sets the context, says it's common for custody sergeants when contacting all London Borough Councils requesting that a minor be transferred out of custody to be told that this is not possible, and she then gives statistics. Now, 2019, you'll see there's a 9-month period to the 30th of September 2019. So paragraph 11 is the number of children charged and remanded in police custody over the last 3 years. So that's children under 38(6, charged, refused bail, remanded in police custody. And you'll see a total of 885 in that 9-month period in 2019, Waltham Forest being 22 of these. And then in paragraph 12, they're broken down into requests made for secure and non-secure. So you'll see that requests for secure accommodation in London are high as a percentage. 2019, 360 secure requests of the total, which is 40%. And in Waltham Forest, it's 37%. So in line with that figure. And then she says 9 secure requests, 11 non-secure requests in that time, in 2019 in a 9-month period. Incidentally, 9 and 11 adds to 20, not 22. We did try to clarify that because paragraph 11 says 22, paragraph 12 says 9 and 11. We didn't get clarification on that in the divisional court, but nothing turns on it. If you then turn to paragraph 13, you'll see the outcome. 2019, in that 9-month period, there were only 57 placements made. And that's 57 out of the total of 885 that you see in paragraph 11. And only 1 to secure accommodation. So London in a 9-month period, 2019, 885 children, 57 placements, 56 non-secure, 1 secure. And then you have the breakdown in Waltham Forest. Waltham Forest is 4 placements. Now, there is nothing in that material to say that of the 9 secure requests, 4 of them were converted. That's an overall figure out of the entire
22.
number. Apologies?
Paragraph 22.
Yes, so this is, you'll see, paragraph 22, there's reference to, I'll come to that in a moment. It doesn't, in fact, contradict my point. So 4 placements is a total number. And you'll see, if you just go back to paragraph 13, 6.4% of total children charged and detained are given accommodation. So that's including secure and non-secure. For Waltham Forest, it's 4 placements. Now, what you then see, paragraph 15 is the point my Lord Justice Elias made earlier, where sometimes police don't ask for any accommodation at all for various reasons. And then paragraph 22, which my learned friend has highlighted for me, does make reference to the fact that sometimes a request is made for secure, and then there's the discussion or the negotiation. But what that says is, that in the 4 requests for accommodation where the child was transferred, 50% of them started off as requests for secure accommodation. That's 2 of them, but ultimately were transferred to non-secure accommodation. So the figures are just not correct. Nothing much turns on this, but we just wanted to make sure the court didn't wrongly adopt the figures which were given, because they're not borne out by those statistics.
In that context, you agree that it is ultimately the local authority that can, as it were, say, I know you've made a request for secure accommodation, but we think unsecured is appropriate.
Yes, and there's a good description of that, in fact, in Gateshead itself.
I'm sorry,
So
I missed that.
it's my fault because I raced through Gateshead earlier. There will be circumstances where a request is made for non-secure and a local authority will say, actually, we think this child poses risks to themselves or to others, and under Section 25, they in fact need secure. That might be an example of where it's impracticable in the circumstances. And there will also be requests where the police officer makes a request for secure, and in fact, there's a discussion, and it can be established that in fact non-secure would be appropriate. So that is correct, and that's part of the way in which the Section 38(6) and Section 21 duties interrelate.
Well, that shows it working.
Yes, although of course there's a public interest in having a reasonable system, and this goes to a point that you made, my lady, and bearing in mind the facts of this case, which of course are just context in the background. It's quite right to say that if actually your answer is inevitably going to be no for secure, there may also be a powerful public interest in ensuring that social workers are not making, or don't have a perverse incentive to suggest accommodation which is unrealistic and inappropriate to meet risk. So there's a factor about that as well.
That's where pragmatic can become risky.
Yes. So, my lady, that's just a short point about the statistics, just to ensure if you are relying on them, the 9.5 is not correct. They're the figures. And you'll see that overall point that is made by P.S. Bullivant is 57 placements of 885 across London. It's only 6.4% of the total. That's a tiny number. That's across secure and non-secure. So it's a very tiny number. And that reflects the picture painted by Just for Kids Law and their evidence, which is indeed of a widespread failure. But of course, my Lord Justice Singh used the phrase, well, this might be a national problem in the sense that it's replicated elsewhere and it occurs in multiple parts of the country. That doesn't necessarily mean that it's a national problem in the sense that it's a central government failure. And that's our point in ground one. It is, as you can see from the evidence, we do not think Waltham Forest is unique. In fact, we're quite clear that Waltham Forest is not unique and that there are many other local authorities on the information available to us who are also in a similar position. But that's not the issue before the court. The issue before the court concerns Waltham Forest and also concerns London and the pan-London information that you have. You simply don't have evidence on other areas. And I should say there are also examples of good practice in the material before you. Can I just give you a cross-reference? Page 263 makes clear that not all local authorities are in the same boat. Reference is made expressly at 263 to GMP, Greater Manchester Police. Their work in 2015. There's significant improvements in the force's procedures for transferring children out of custody. And indeed, up to 80% of transfer requests under Section 38(6) are being accommodated. And the court may be aware Greater Manchester Police was the subject of a number of cases which involved deaths of children in police custody. There's been evidence in other cases on that. And you'll see from the trajectory of the Concordat that was part of the motivation behind Greater Manchester Police's engagement with the Concordat and being an example of good practice. They're simply not all in the same boat. But on that point, the statutory obligation, as my Lord Justice Elias said, is on individual local authorities. So the fact that this is replicated in other areas doesn't change our remedy. Our remedy has got to be against an individual local authority because that is the statutory scheme. And it's wrong to say this is like negligence. If everybody does it, it's difficult to say it's negligent. There's no equivalent of a reasonable professional test which should apply here. And I'm minded to think of the Section 20 case law, which went to the Supreme Court, series of cases going to the Supreme Court around 2007, 2008, where you have Lady Hale saying, I cannot believe I'm having to hear yet another case about a failure of Section 20. We've already made the law clear. We've set it out. So you've got the G case and a series of other cases where there's replicated failures. In fact, that makes it all the more important when it comes to relief, we say, that the court does grasp the nettle and does, in fact, take the opportunity to give an indication of how local authorities should deal with these issues. And this is what public law is for. So Aor is long out of custody. He's had his situation. he could indeed have had the same situation, even if Waltham Forest did have a reasonable system. On the evidence, we say they didn't have a reasonable system then, they don't have a reasonable system now, and there's a powerful reason for the court to grasp that when the material before you suggests other local authorities are in a similar position. Yes?
Sorry to interrupt you on this, but this may become important, and I stress again that we have no view, whether provisional or other, but since you've raised the possibility, speaking for myself, I'm very concerned about courts giving advice or advisory declarations. What courts do is decide on a set of facts whether there's been a breach of the law. And so one can make a declaration that current arrangements are unlawful because they are irrational. But a moment ago, you suggested that what the court might do is tell local authorities up and down the country what they should be doing. And I'm not sure that we're really in a position to do that.
No, and again, my lord, I agree with you. And in fact, what I was coming on to say is that the suggestion was made that there's a powerful indicator here that Waltham Forest is not behaving irrationally because other local authorities are in a similar position. So we're simply making as a rebuttal point an argument that that does not follow conceptually. I entirely agree that we cannot comment on other local authorities outside the consortium, as my lady indicated when speaking earlier, because reasonableness is fact sensitive. I indicated earlier in response to your question, and my Lord Justice Singh, about reasonableness and the Section 82 of funding requests being refused, and we said our view is it's highly fact sensitive. It will involve looking both at current provision and steps being taken where there's a gap. So you could well have a situation where you have an end result which is rather similar to Waltham Forest, but it nevertheless is the product of a reasonable system. So, and of course you can't comment on that, and you can only comment on the facts before you. We recognise that. And that comes on to another concern that we have, which relates to the evidential gaps in this case. Just before I turn to that, may I deal at its core with the very candid submission made by my learned friend, which is really the short point at the heart of this case. He said right at the outset, very fairly, can it ever be met when there's a Section 38.6 request? Overnight, no. Weekend, probably yes. So, and he later then very fairly said, either pooling is good enough where you can provide accommodation at the weekend or not. So our first point is that a system which involves for 5 days out of 7 an inevitable no is not a system which this court should consider to be a reasonable one. There's nothing to indicate in the divisional court's judgment that the divisional court understood that to be the argument that was in fact being made. If it's not capable of ever meeting requests made on a Sunday, Monday, Tuesday, Wednesday, Thursday for any child, 5 days of the week, in our submission that does not meet the Gateshead duty. That is not an approach which a reasonable authority, in line with the policy and objects of the statute, and indeed in line with the international requirements under the UNCRC, Beijing rules, and the Council of Europe guidelines, could reach. That is not a reasonable decision, and not a reasonable system. But the second point is, exercise caution when told the answer to the weekend is probably yes. Where is the evidence of that in the material before you? There is no evidence before you to show that for weekend requests, the answer is probably yes. There is no proper evidential basis for that. There's no evidence of how early a child would have to set off on a Monday morning, even if they were accommodated. Is it a 4 a.m. start? We simply don't know. So when they say fairly, overnight, Sunday to Thursday, we can't do it, we say that's not a reasonable system. But we also say the assertion, without an evidential basis, that at the weekend the answer is probably yes, you should exercise real caution. Judicial eyebrows should be raised at that submission, because we simply don't have evidence of that before us. So in fact, we say the system doesn't even meet that very low bar of having a probable yes at the weekend on the evidence before you. There's no evidence to indicate that at all. And this comes back to the issue about the evidence before you, which of course is critical in judicial review. You've seen in our submissions our concern that judicial review should indeed be a cards on the table approach. And my learned friend made reference earlier to there being some straws in the wind. When you look at Miss Gordon's statement, you get some material. But this is a situation where we asserted, set out in pre-action correspondence, we didn't believe there to be a lawful system. The Metropolitan Police provided the statistics suggesting in our submission that there's not a reasonable system. And the evidence that's been provided by the respondent is very thin. Now, this is not a new point. My learned friend said earlier, if this had been put earlier, I would perhaps deal with it as if it was a new point this afternoon. That's not correct. I'll just give you the references. First, right at the outset, this was set out in the pre-action letter, and indeed, failure of record keeping by the London Borough of Waltham Forest was pleaded as a separate ground. Ground 3 originally, see page 135 of the core bundle, paragraph 4.28.
I'm sorry, the pre-action protocol letter, what's the reference for?
In fact, I think the pre-action protocol letter may have been pared down in our effort to make the bundle a bit more lean. So I think that may have been removed.
Don't worry.
But you'll see references to the pre-action protocol correspondence when we make this point later, and I'll give you those references. That was a whole separate standalone point about how can they possibly make decisions when they don't gather the right information, a Tameside type point. But this still goes to the reasonableness of their system on the issue before you today. And
Sorry.
may I ask you to look at... Yes?
Also add that it was refused permission.
Yes, of course, I was, yeah. So that of course, that ground was refused permission. So there were 3 grounds originally. Ground 1 was this point about the reasonableness of the system. Ground 2 was about the decision-making in AOR's own case. Ground 3 was about Waltham Forest's failure in record keeping. That's how it was pleaded from the outset. So the second point I was going to give you was in the skeleton for the hearing below. You'll see very clearly, spelt out in black and white, our concern about the inadequacy of the evidence provided by Waltham Forest. Page 75, paragraph 1.7, page 87, paragraph 4.15. So this is not a new issue. We have been concerned about it throughout, and it's part of the reason why the court erred in concluding this was an adequate system, and why we ask you to decide this case differently now. Now, on evidence, the first we have heard, and I am certain of this, it was 3:15 this evening. I made no complaint about the time because, of course, 3:15 is due to me taking rather longer this morning. We were told this morning in submissions to you, not supported by the statement which we received at the end of last week.
Do we need to go into this at all? I mean,
No, I just wanted to say...
They become relevant
Yes.
when relief is in it. You can make whatever points you want then, but we don't want to we knew then and forfeit.
Of course. I'll just make it very quickly because it is important. There has now been a reference to how there will be an application in respect of PACE placements. Now, we don't see that on the evidence before us. If that point is going to be made, we must have an opportunity to respond to it fairly. And we take the point, which my learned friend has very fairly made, that he doesn't, in fact, pray this in aid as an answer to the substantive case. He's not praying it in aid as an answer to points 1 to 3. It's an issue which goes to relief. And bearing that in mind, we thought a sensible approach would indeed be, if the court agrees, for us to address the question of relief if there is further evidence coming, because it's so closely interrelated with that point. But I'm in the court's hands on that. We have set out, at first instance, a paragraph as to why we say the appropriate relief is declaratory relief. It's paragraph 7.1 to 7.2 of our skeleton below, pages 90 to 91, and the paragraph I referred you to earlier in respect of ground 4. We rely on all of those points, but if the court were minded to get the further evidential underpinning and the written basis for the point made on instructions this afternoon, and then to look at relief at a later stage if we get to that point, we're quite happy to address you separately in written submissions at that point. I'm in your hands. Thank you. Could you just give me a moment? Of course. Thank you very much.
Should we just agree a timetable for anything further in writing?
Yes, I think so. I think we're just going to, in the light of what's come up about potential further submissions and so on, I think we'll just rise for a moment so that we can devise a plan together.
Thank you.
Don't go away, we'll only be a quicker
if they go away.
We need to see it.
Absolutely. processes.
Do you know on the written material how quickly that could come in?
I don't, because I don't know who's got it.
Yeah.
This is the trouble with these
Yeah, yeah.
bureaucratic bodies.
Yeah. It doesn't even have to be the whole application, it's just confirmation of what covers.
Yeah, obviously we're trying to find out.
Yeah. Okay.
I can't see any problem with finding it within certain days. It's got to be wrong by the 6th of July, then it must be available within that.
My stuff. Have you seen my notepad? I brought it. Actually, I've got a rather inappropriate bag with me today.
Excellent. Don't go anywhere near the Home Secretary.
Actually, are you getting a proper break? Are you away in August?
Sorry?
Are you away in August?
Ideally, yes.
Yeah, you're going to get a... I mean, I have to say, of all years, I really need a break this year.
Oops, strange times.
Ms Gallagher, first things first, you're going to answer some questions put by Lord Justice Singh in writing. Would 4 o'clock on Friday be practical for you?
Yes.
We're working on the basis you'd prefer to deal them while it's still fresh in your head.
Yes, and in fact, I could have done them today if I'd been a little faster in my reply.
Don't worry about that.
We're happy to do them by 4 p.m. Friday.
Thank you very much. Mr Underwood, we don't anticipate asking you for responses at the moment, given that it's a straightforward response to questions from the bench.
Quite.
But if when we see them that we feel it's not fair, if you don't have a chance to respond, we will come back to you.
That's very
I
kind.
can reassure you of that, but we're not going to timetable that. Then we'll be handing down a draft judgment in the normal way. Initially, of course, for the normal typographical, grammatical, and minor factual errors that may appear, but obviously not an opportunity to re-argue the case. It may be that we will, at that stage, while it's a confidential draft form, it may be that we will ask you for any submissions in writing that anyone wants to make about the Supreme Court's judgment in Re T, if we have it. And it may be that we, if the appeal is allowed on the substantive grounds, and obviously we don't know yet, but if it is, then we may request further information. We don't, again, wish to timetable that at the moment because we don't know whether it's going to be required, and we don't know when the judgment will be given in any event. So does that work for you?
That's very kind, yes. And behind the scenes, we'll use our best endeavours to get hold of this application and give it to my friends anyway.
Well, I think that'll be a gesture of goodwill in any event,
of course.
The concerns of the appellants.
Yes, that's really fair.
Yes. Well, I'm very grateful for that. That's fine. So we'd hope, therefore, that anything else can be dealt with in the normal way, with any other matters dealt with in writing, and hopefully agreement about an order and any orders of costs and so on. Well, you've got your costs are more effectively dealt with anyway, aren't they? The judgment will be handed down electronically, I anticipate, under the COVID regulations.
Thank you very much.
Ms. Kelly, you're about to draw breath.
It may not be possible to say. I just wanted to indicate we have a rather large percentage of people who are primary carers on our legal team. So we have commitments over over August and for school holidays.
Of course.
So I'm just conscious we're relatively close to the end of term. So I just wanted to indicate that. We'll of course be as available as possible. But once we hit the end of term, we're in a little bit more difficulty for making further submissions. I just say that on the off chance if it comes late and in July and we have to make submissions,
Ms. Gallagher,
I'm afraid we may need to ask you for some time.
I can absolutely assure you that whilst any of us are in the Court of Appeal, the days when people don't take into account people being primary carers or having children are long past.
Thank you. Very grateful.
Anything else that either of you wish to raise in the light of the slightly unusual course that we take?
No, thank you very much, my lady.
Well, can I thank you all very much indeed. I'm very conscious of both the importance of this matter and the huge amount of work that's gone in on both sides, and we're extremely grateful to both legal teams and of course to each of you.
Thank you.
Thank you very much.